I'll never forget the morning everything changed. The sun had just crept over the horizon when I heard boots crunching on the gravel path leading to my ranch gate. Through the kitchen window I watched a sheriff's deputy approach with a manila envelope in hand. My coffee mug froze halfway to my lips as he stapled in official notice to my wooden fence post. The bold letters at the top made my stomach drop. Lean notice below that in black and white was a demand for $3,800 in unpaid HOA fines, all because of the very fence the deputy had just defaced. With his stapler my hands shook as I read through the document. This couldn't be happening. 6 months ago I built a simple split rail fence around my 5-acre property. Nothing fancy, just traditional wooden rails that matched every other ranch in the county. But apparently matching the local aesthetic wasn't good enough for the Willowbrook Estates Homeowners Association. Let me back up and explain how a working ranch ended up under the thumb of suburban busybodies. 20 years ago this area was all farmland and ranches. Then developers bought up parcels here and they're building McMansions between the remaining agricultural properties. When they created Willowbrook Estates they somehow roped existing properties into their HOA jurisdiction through some legal maneuvering I still don't fully understand. Most of us old-timers ignored them, figuring they'd leave us alone. Big mistake. I raised chickens and goats on my land, nothing commercial, just enough for eggs and milk. The split rail fence was necessary to keep the animals from wandering onto the road. It's the same style fence my grandfather built on this property 70 years ago, but according to the HOA it violated their aesthetic guidelines. The first fine arrived 2 weeks after I completed the fence, $100 for unapproved exterior modification. I called the HOA office, explained that this was a working ranch, not a suburban lawn. The secretary, a nasal-voiced woman named Brenda, told me to submit a formal appeal to the Architectural Review Committee. So I did. I filled out their forms, attached photos showing how my fence matched traditional ranch fencing throughout the area, and waited. The response came a month later. Appeal denied. The fence failed to meet community standards for boundary demarcation, whatever that meant. Along with the denial came another fine, $200 for continued noncompliance. I was starting to see a pattern. I decided to attend the next HOA board meeting held in the community center every third Tuesday. Walking into that fluorescent lit room felt like entering enemy territory. About 30 residents sat in folding chairs facing a long table where 5 board members presided like judges. At the center sat Karen Whitmore, the board president, mid-50s, bleached blonde hair shellacked into a helmet, wearing a blazer that screamed, "I demand to speak to your manager." When they opened the floor for resident concerns, I stood and calmly explained my situation. I'd lived here for 20 years. I said the fence was necessary for livestock. It matched the rural character of the area. Karen's lips pursed tighter with each word I spoke. When I finished she leaned into her microphone with a condescending smile. "Mr. Thompson," she said, drawing out each syllable like she was talking to a child. "Willow Estates has standards. We can't have every resident doing whatever they please. Your fences weathered wood. Our guidelines clearly state all fencing must be white vinyl or ornamental iron, no exceptions." I pulled out my copy of the guidelines. "Can you show me where it says that? Because I've read these 3 times and there's nothing specific about fence materials." Her face flushed red. "It's implied under general aesthetic standards. The board has discretion to interpret the rules for the good of the community." The good of the community? I couldn't keep the sarcasm out of my voice. My ranch was here before your community existed, and now it's part of Willowbrook Estates. She snapped back. "If you don't like our rules, perhaps you should consider relocating somewhere more suited to your lifestyle." The room went silent. Several neighbors shifted uncomfortably in their seats. I saw Jake Harrison, who lived 2 houses down, shake his head in disgust, but nobody spoke up. That's how Karen maintained her iron grip on the HOA. Fear and intimidation. I left that meeting knowing this wasn't about my fence. This was about power. Karen had found someone who dared challenge her authority, and she was going to make an example of me. The fines kept coming, $300, $500, each one escalating, each one adding late fees and interest. I tried calling board members individually, hoping to find a reasonable voice, but they all deferred to Karen, terrified of crossing her. By month for the fines totaled over $2,000. That's when they started adding legal fees for enforcement costs. I hadn't even been taken to court yet, but somehow I was being charged for their lawyers' time. The whole thing felt like a shakedown. Desperate, I started researching HOA law. I spent nights poring over state statutes and legal precedents. Most of it was mind-numbing legalese, but then I found something interesting. According to state law, HOA bylaws had to be properly ratified by a supermajority of homeowners. The process required specific notifications, waiting periods, and documented votes. Curious, I submitted a formal records request to the HOA for all documentation related to the adoption of the current bylaws. Brenda tried to brush me off, claiming the records were archived and would take time to retrieve. I insisted, citing state transparency laws. 2 weeks later, she grudgingly handed over a banker's box of faded documents. I spent the weekend going through every page with a magnifying glass, meeting minutes, correspondence, voting records, and that's when I found it, or rather didn't find it. There was no record of the current bylaws ever being properly voted on. The board had simply adopted them by fiat 15 years ago, assuming nobody would challenge their authority. My hands trembled as I realized what this meant. If the bylaws weren't legally adopted, then every fine, every lien, every enforcement action taken under those bylaws was potentially invalid. This wasn't just about my fence anymore. This was about years of illegal governance. I needed a lawyer, not just any lawyer, but someone who specialized in property law and wasn't afraid to take on entrenched interests. After several consultations, I found Patricia Chen, a former district attorney who transitioned to civil practice. She reviewed my findings, and her eyes lit up like a prosecutor who just found the smoking gun. This is huge, Patricia said, spreading the documents across her conference table. If we can prove the bylaws were never properly ratified, it doesn't just void your fines, it potentially invalidates every enforcement action they've taken for 15 years. We filed our lawsuit the next week. The complaint challenged not just my fines, but the legal authority of the HOA board to enforce any rules. Within days, the HOA's attorney was calling Patricia, trying to settle. They offered to waive my fines if I dropped the suit. Patricia laughed and hung up on him. Word spread quickly through the neighborhood. Suddenly, people who'd been too scared to speak up started sharing their own stories. The Johnsons fined $800 for painting their door the wrong shade of beige. The threatened with foreclosure over unapproved landscaping. Years of petty tyranny bubbling to the surface. The HOA tried damage control. Karen sent out a newsletter claiming I was a disgruntled troublemaker trying to destroy property values, but the seed of doubt was planted at the next board meeting. The room was packed. Residents demanded answers. How were the bylaws adopted? Where were the voting records? Karen's usual tactics of condescension and intimidation fell flat against a room full of angry homeowners. She tried to table the discussion, claiming it was a legal matter that couldn't be addressed in open session, but Jake Harrison stood up and wouldn't be silenced. We have a right to know if you've been illegally finding us for 15 years, he said. Others joined in, voices rising. For the first time since I'd known her, Karen looked genuinely frightened. The court date arrived on a crisp October morning. The HOA had hired a team of expensive lawyers, all dark suits and leather briefcases. They tried every procedural trick to get the case dismissed, but Judge Margaret Sullivan, a nonsense woman in her 60s, wasn't having it. Patricia presented our case